for a presentation by Pettit Kohn. We've got Ryan Nell here, shareholder at the San Diego office. He also has a practice in the LA area. And today he'll be talking about reading between the lines, developing best practices from what the law doesn't say. Ryan and I know each other. We actually work together. He represents my organization, and so we've called on him several times already in my short time here so far. And he's been a great advisor. And I know he also does litigation and trainings, which we're looking forward to later this year. So take it away, Ryan.
Great. Thank you, Diana. Thank you, ACC. Thank you, everyone, for allowing me to be here and come back. I've had the pleasure and the privilege of speaking. I gotta minimize myself. Sorry, technical difficulties. There we go. Of speaking at a number of in-person and remote ACC presentations, conferences, and the like. I love it, and I mean that because very often I speak, as we were talking about, with the group as people were logging on. Typically, my audience is HR professionals, which is great because often that's who I'm handling matters directly with them. The audience is a little bit different here because now I'm talking to attorneys, or not exclusively, but for the most part, attorneys as we're speaking to ACC. And so the sensitivities are very similar, but also in some ways a little bit different. So I want to talk about that and use that as a springboard to kind of create a new conversation. Now, I think I can see I have a chat open up. So if anybody has questions, feel free to do that. However we want to jump in. We can be really flexible with this. If you've seen any of my presentations before, I know the bumpers of what I want to discuss, and I promise I'll stay within them, but I welcome tangents. I welcome wherever we can go with this stuff, because I think the most important presentation is not what I want to say, but it's what you want to hear. So let's make this that. Today, what we're going to talk about is reading between the lines. And what I wanted to get at with this, I was going back and forth with Audrey from ACC about what I think would be an interesting topic particularly for ACC attorneys and all of you in the crowd here today. And so often presentations are, here's what the new laws say, right? Well, especially at the beginning of the year or the end of the year when laws are passed, attorneys like me will stand in front of a group of you and we'll talk about, here's what the new stuff says. And we'll look at it in the vacuum of just the new cases, right? So this case said this case said this case said this. And what can sometimes be lost in that is the bigger picture trend, right? We take half a step back. You say, what is it that either the legislature or the courts, whether it's the state Supreme Court, appellate courts in the state, in some instances, the United States Supreme Court, what are the trends that we're seeing as we look at these laws that come down the pipe? Now, here's the disclaimer, right? This is, it's mostly tongue in cheek, that I don't know exactly what the state Supreme Court thinks about things. I just know what the pattern is that we're seeing as California employment attorneys, right? Which is when we see a couple cases in short succession and we look at them and we think what might be coming next, or what is it that the courts and the legislature are trying to tell us. And I think that is what helps us develop the best practices as employers to try to stay out of trouble that comes down in the future. Reason I say this, and the reason I think this is hopefully going to be a good topic, it's a new one, so let us know in the comment cards, is that most law is retroactive. In other words, when these Supreme Court decisions come down, for the most part, what the courts say is we are interpreting existing law. In other words, we're not creating something. We're not saying from this point forward something exists. We're saying this is the way the law has always been and we interpret it as such. So what does that mean? It means that if you're not trying to look into your crystal ball and trying to find areas of compliance or opportunities for compliance, you might be half a step behind. Because what happens when that Supreme Court case comes down 6 months from now, and lo and behold, the thing that you thought was the case, or the interpretation you had, or let's face it, in some instances, the fact that you buried, not you personally, but your organization or organizations with which you do business, bury their heads in the sand about what could be the case. Now, all of a sudden, you're not in compliance, and there is nothing you can do about it because you can't look back and you can't cure. Speaking of cure, the elephant in the room that we all may want to talk about is PAGA. If you are in the loop on all this, which I suspect most, if not all of you are, there were big changes in PAGA law that just came into effect in the middle of last month. This is not a PAGA presentation. You've all probably been to PAGA presentations. already because they're coming out in droves. If there are questions about PAGA, however, I am more than happy to address them. I can try to leave some room at the end and we can circle back because that may be what the crowd wants. And so I want to give people what they want. But for the most part, I'm not going to address PAGA at least head on. We can talk about it as time permits later on. So without further ado, here are it's like 8 or 10 different subjects that I think in the world, according to Ryan Nell, which is just me, that are areas where the courts and the legislature are telling us something. So first, we go to the concept of paying for all time, right? It used to be, and this most often comes up in the context of class litigation, right? Because sometimes you'll have individual claims for wage and hour that are usually relatively small, right? Someone says, well, I didn't get paid X, Y, and Z. If they're an individual, the value of that claim is quite minimal. I'll give you an example. I was in an arbitration end of last month where there were some wage and hour components, but it was, in that case, it was rest periods. And the argument was that this employee missed a handful of rest periods. Well, the value of a handful of rest periods, before you take into attorney's fees at least, is pretty minimal. That's okay. But if you look at it and you aggregate it over the course of the class, and I recognize some of the names on this list, and so I know that some of you are at very large companies. And when that's the case and you aggregate it over hundreds or thousands of employees, it becomes a whole lot bigger. So it used to be, and perhaps I'm preaching to the choir, some of you have dealt with this firsthand with me or with my firm, that just about every class action or PAGA, which again is going to change a little bit, but it's still the same concept, you have the same conversation, which is the lawsuit gets filed, you go in, and once you get the lawsuit, you answer and you get a call. You get a call from opposing counsel who says, hey, here's what we're going to do. We're going to press pause on formal discovery. We're going to exchange informal information, and we're going to discuss the prospect of early mediation and trying to get a case resolved there. Great. And in the process of doing that, you exchange some redacted data, you share a class sample, so call it 25%, 35%, something like that of the class data. Everyone analyzes it, they come to a mediation, they put their data together, and if all goes well, you get to a number that you were expecting in the first place. But there's one really important thing that used to be a part of that calculus that no longer is. In all of our briefs that we would submit to mediators, we used to always say, hey, if there were violations, they are, quote, de minimis, right? That there is, it doesn't really matter. It was here and there, as a couple seconds here, a couple seconds there. And then there was a case back in 2018 that dealt with this and happened to be for Starbucks. And in that Starbucks case, it dealt with the fact that some managers, hourly managers, not exempt managers, had some or had some isolated tasks that they had to do. And they had to perform those after they clocked out. So they would clock out and then they'd have to lock the doors. They'd have to, in some instances, walk coworkers out to their cars to ensure they got to their cars safely, things like that. Now, the argument was, it's a couple seconds here, it's a couple seconds there, that doesn't need to be compensated. The court said, no, that's not the case. That time needs to be compensated. We do away with de minimis. And in 2018, we saw that and we said, okay, great, we can't put that line in. And that would be enough. But now we saw a trend. And really, this is kind of where the genesis for this entire concept came, because this is I think the cleanest of the trends that we see, which is paying for all time work. Because then in 2022, we got 2 more cases that deal with how we compensate our employees. So we now know that there is computer booting time needs to be compensated. So that was another thing. You may have, if you work in an office, you have employees that come in and they need to log into their computer. And that's what the Cadena case said, is that time spent logging in or waiting for a computer to boot up, that's compensated. And you looked at that in a vacuum. And then you learned other things. We now know there's a recent case, I didn't put it on the list because I limited it to 3 at most per category, but there's a case that recently said time spent if you're walking to the punch-in station, that time is compensable, right? And all of this then gets to the same concept, right? Which is we need to find a way to pay our employees for all of their time work. And what I caution all of you, or I highlight to all of you, is the importance of not just looking at these factors as they relate to the specific cases, but to the big picture, which is the California Supreme Court is telling us we're going to continue to issue rulings that continue to put this fine point, that no matter what the industry, no matter what it is you're doing, if someone's on our property doing our work under our control, we need to pay them. And that, oh, it takes a couple seconds here and there. Absolutely not. The icing on the cake of that is Camp versus Home Depot, right? We can't have, well, with extremely limited exceptions, we can't have neutral rounding policies anymore. Same concept. The idea is that if you have someone there, we're all using or should be using either biometric or swipe cards or whatever it is for our employees to clock in and out. It goes to the millisecond. Why would you now take that data and round it? Because what happens there is you're not paying your employees for all time worked. The wisdom makes sense, right? If someone is, say they're starting at 8 o'clock in the morning, they're far more likely to arrive at 8:57 than they are at 9:03. And the data almost always backs that up. People usually arrive a little early rather than a little bit late, which means if you're rounding both of those to 9 o'clock, in practice, you're getting more time. Think of all of these in concert with one another and take them as an opportunity to go back to your organizations and look at the way in which you're compensating your employees, capture all. If it's an office, find a way, or it's an office, say it's in an office park, you have multiple places where your employees are working, find a way to capture the time where they're in your control. The way I think of it is if someone, a manager, whoever, can say, hey, Jim, you're here, start doing something. I have a question for you. I'm going to stop you and ask you about this work-related thing. If there's an opportunity for the boss to say, hey, Jim, I need to ask you a question, and Jim hasn't been able to get clocked in, there's a problem. You need to be compensating Jim for that time because he is effectively, or should be on the clock, he is effectively working for you. So think through that for your industry, specifically for what you do, and find a way to compensate for all that work. It's really important. There are going to be more cases on it. That's why we do this. Arbitration agreements. Now, when we talk about arbitration agreements, there have been a lot of changes over the years to the way that they've been enacted in California and elsewhere. The short way to think of it is that California doesn't really like arbitration agreements. The federal government, the United States, does. And so we have a way where we try to enforce arbitration agreements under the FAA, Federal Arbitration Act. And we have factors that need to be applied to ensure their enforceability here in California. And those factors put a rather fine point on things. They're called the Armendariz factors. They're not new, right? If I had 10 bullet points for this, I would go all the way back to Armendariz to say that's what creates the standard by which we seek to enforce our arbitration agreements. But that's the standard, and that's not going to change. What we now know is we have a sharper point on all of this, right? The sharper point that we have is how we ensure that client or that employees sign the arbitration agreements. The arbitration agreements included what we intended for them to include, and they are enforceable in the way in which we intend for them to be enforceable. Here's the scenario that plays itself out sometimes, and I'm going to say this about the collective all of you, or the generic all of you. Arbitration agreements are specific. So if you called me or you called any employment attorney out there, somewhere there's a form, right, that I can, with some limited exception, just say, okay, here you go. Here's your company name. It's easy. What often happens, and it's often inside company or general counsel or inside counsel, that will take it and go, thank you for this. I'm now not going to tell you about this, but I'm going to make some changes. Please don't do that, because here's what happens. Those changes that you make often mess with the factors that are considered in the enforceability of these agreements. So, for example, the Armendariz factors look at whether or not the recovery by an employee is the same as it would have been in superior court, right? So you have someone, you're trying to take their claims out of superior court, or state court, or in some cases federal court, and trying to bring them into private binding arbitration. If you, as the smart general counsel that you are, go, here's what I'm going to do. I'm going to make it so that attorney's fees are capped at a certain threshold, or emotional distress recovery is capped at a certain threshold. And I'm going to be okay with that because the employee is going to sign it, and it's an arm's length transaction. The employee agrees and understands that this is the case, and therefore he or she is going to sign their life away. You do that, and they sign it because they don't read it, or it's their first day of work, and they're not going to ask questions. And then you think you have this great piece of paper. And then when that person quits or gets fired and they file a lawsuit and you seek to impose or to apply that arbitration agreement, I need to explain to the court why we should sever that provision that's not appropriate. And sometimes the court sides with me, sometimes the court doesn't, because ultimately the question is whether or not it's, quote, permeated with unconscionability, right? And there are a couple different factors that we look at in that. But the idea is this so unfair from a, in this case, substantive standpoint, so as to offend the conscience? Say, well, hold on a second, this changed it all. I'll give you an example. I have a case, and this is not, there's no malice to this. It's just, it's an old agreement. I have a case where an employee was hired some 20 years ago, and he signed an arbitration agreement at the onset of his employment 20 years ago. Included in that arbitration agreement were lots of provisions that just flat out don't fly anymore. And so what we had to do is file a motion that says, yes, this is what he signed, but really just focus on the top part that says, I agree to binding arbitration, and we're going to agree to change all the other stuff. So I had to have someone from the company say, even though it says that there's only this type of recovery, that's not the case. Even though it says that the costs of arbitration will be borne equally by both parties, that's not the case. They'll be borne by the employer because that's what's required under California law. All of those things, there are 5 different things that I had to say and qualify. Now, the hearing's in a couple months, I'll let you know how it goes, but it's tricky. Now, in that case, the only thing they could have done is given a new arbitration agreement since his employment started, which companies don't always do. But the point is, if you have these agreements, you need to play by the rules. That backdrop gets us to a couple cases that have continued to show that, right? We have the ending forced arbitration of sexual assault and harassment. What that did is it means that if you don't have, if you have a sexual harassment claim in a lawsuit, you're not going to arbitration. Now, what does this mean from a practical standpoint? It means that we're going to see more sexual harassment allegations. For better or worse, they're going to be included. We're going to talk about retaliation later today. Very similar concept, right? Where there are more retaliation cases because the law has changed in a way that favors employees. The same is going to be the case here. We're going to see sexual harassment allegations anywhere that there's a colorable argument, because that allows employees to stay out of arbitration, to stay in superior court. Not much we can do about that other than understand that existence, right? Because then why is it, what is the leverage that we have? What is the proposition that we're trying to protect of trying to get into arbitration? How can we try to do that? But we can't do it by trying to negotiate out on the front end by saying, well, you can't bring a harassment claim. That's not how it works. We also have questions about execution of agreements, right? Especially in this modern world where most, well, not all, for all companies, but for some companies, all agreements are electronic. Well, courts are looking even more closely at how and where and when and to what degree of certainty agreements have been executed, right? So that's why we have this Gamboa case from a couple of years back that looked at, well, how do we know? And what I'm telling you, less so on the particular holding of that agreement, but more so just from an evidentiary standpoint, I really want you to put yourself in a position where you can authenticate the fact that someone has signed an agreement. Now, you may have everything be electronic, and that's okay. Make sure you have processes in place, because here's how this works in practice. If I have to file a motion to compel arbitration, I need to have a declaration from someone. Usually it's an HR person or a C-suite level employee. It could be general counsel, potentially, although preferably not, that will explain, here's the process. The employee has a unique username and password they create. They're the only one who has access to these documents. Here's the timestamp that says this document was signed on this date, and therefore it confirms the same. That's the ideal. That doesn't always happen. And what we want to do is we want to be in a position where we don't run into the issue of something like Gamboa or similar, where all you have is an HR person saying, oh yeah, that person signed it. We want there to be more. I would love for there to be wet signatures on these. Now still, there are ways to try to argue around that, but at least if it's someone's signature, you can argue that it's authentic. All of this, as it relates to arbitration agreements, goes back to the burden or to the point of trying to get the benefit of the agreement that which you tried to bind yourself, right? You put the time, the expense, you created this protection, right? In the class action context, you can avoid an entire class action if the plaintiff filed or executed an arbitration agreement. Make sure you have what you need. And then you got to make sure you pay. And this is really important. There have been a few cases that have dealt with this over the years. The Doe case is one of them, but it more stands for the proposition of the vital nature of timely payment of arbitration fees. The law says that if an arbitration fee is 30 days late, the case can get remanded back to state court. You can pay sanctions. You can lose your right to arbitrate any case with that arbitration company. The circumstances or the potential downfall is huge. In this particular Doe case, it was a mailbox issue, right? So they sent a check was due on Friday. It was sent in the mail on Friday. It arrived on Monday. The court said, sorry, that's late. You can't do it. Too bad. This is really important. I know that there are some bills that, invoices will sit and we'll wait till the next quarter or we'll wait to whatever. Arbitration invoices, vitally important. So what is the message with all of this? The message is that the courts in California are still going to respect our right to have arbitration agreements, but they're going to put really sharp edges around it. And if we as an employer step outside of those edges, either because we don't do a good job of confirming signature, we put terms in the agreement that aren't appropriate or outside the scope of what they should be, or we don't follow the rules once we're in arbitration, we're going to lose the right to arbitrate. Don't put your companies in that position. Help stay out of harm's way. And that's the easiest way to do it. Okay. Moving on, COVID-19 fallout continues, right? We are now a little over 4 years removed from the onset of the world changing. And for the most part, we are out of the woods, right? We're not dealing with the same emergency regulations. We're not dealing with laws that come out, and I've got to read a 90-page thing from the governor while I'm trying to answer questions with clients on the phone about what that 90-page thing means. That fire is done, but we still see fallout, and I want to think about the concept that applies to it, right? And what we can take away from it, is I feel that that's really important. The first is as it relates to compensation for employees. Now, what IBM did in this case, they had a good lawyer. It wasn't me. It wasn't my part. They had whoever it was a good lawyer, because the lawyer was creative in trying to get around the fact that they weren't reimbursing their employees for time worked at home. And so what they said in an interesting argument that didn't win, but it was an interesting argument, was, well, the employer didn't cause the work from order, the governor did. Right? The state of California sent people home, and therefore that's the reason that someone's home. And therefore they weren't required to do it by the employer, they were required to do it by the state, and therefore they should not be reimbursed. And I'm almost positive this is the California Supreme Court. Don't quote me on that, but the point is it's good law. Said, thanks, good argument, appreciate where you're coming from. Absolutely not, we don't buy it. Point is, you need to reimburse. Now, there are a few things and few reasons why I raised that. One is that even though we're 4 years into COVID, we're seeing companies that are not reimbursing their employees if they need to work from home. So if you've gone full remote in these 4 years, what's the saying? The best time to start doing it was the first opportunity you had. The second best time is now. I just bumbled that, but the idea is go and fix it. Do what you got to do. True it up. Say, hey, employees that we require to work from home, here's a payment. Cut that out. Because if you can cut that out, you're not ripe for the picking for litigation, or at least not as ripe, and you can do away with it. That's going to help do you a lot of good. You also just want to look at your practices for remote workers. So that's the takeaway that I see from the COVID stuff, is that the world has changed, right? You don't need me to tell you that. But you have far more remote workers. They're held to different standards, or in terms of attendance, that is. But they should be held to the same standard of doing work. So what you need to do is you need to continue to find that balance where folks can be held to the standards they're required to do the job they're required to do. They're still held to that, but you don't make yourself easy picking for employment. This is an interesting case that I added because I just think it's important in the COVID context, and we haven't had a ton lately, which is that there's not a duty to prevent spread to household members. That candidly stands a little more on its own, but what that tells me from a reading between the lines standpoint is we're kind of emerging from this, right? So what will remain are the concepts of remote work and hybrid work and reimbursement, and where is your normal business address? I think that's a big issue, right? If you have someone who where they normally work every day is from home, and then all of a sudden you make them come to the office, well, there's a colorable argument, unless you've defined it differently, that their primary workplace is home. So there's a good question that just came in, which I'll answer in just 1 second, or I guess it was just to me, but it was a good question, and I'll address it. Is define it. Tell people, here's what we expect of you. This is where your home office is, whether it's their home or whether it's your home office. So that way it's defined. There's a good question that came in about what work from home business expenses are reimbursable. Here's what I would prefer you do. Give it as a reimbursement for everything that's work from home, right? Rather than define it. And I know I may be preaching to the choir for some of you, but I think this is important because I see companies still not doing this the way I would prefer, which is if you say, okay, here's a reimbursement for your internet, or here's a reimbursement for your ergonomic desk, or for your monitors, or whatever the case may be. What that does for me, and I think like a cynical defense attorney, but to me, a plaintiff's attorney is going to look at that and go, okay, I'm going to figure out what is defined, and then I'm going to try to go after the one that's not. Right. So if you say you're going to pay for internet because you need to use internet for work, or for a desk because you wanted a stand-up desk, but you don't pay for the chair, you don't pay for just say, here's $150 a month, or whatever the right number is. Give it to your employee and say, this is a reimbursement for work from home expenses. If you feel that that is not appropriate or not the right amount, let us know. That gives you a good opportunity to get out. The example here is as it relates to cell phone reimbursement. Right. There's no law that says here's the right amount for cell phone reimbursement in terms of dollars. The law just says you must reimburse for cell phones, even if it's family plan or whatever. You still have to reimburse for it. So what I like for policies to say in the cell phone context is employee, and it can be different levels depending on employees, whatever it is, but employee X, you, based on your position, we are going to reimburse you $50 a month because we feel that that's appropriate for the cell phone usage tied to your job. Then you say, if for any reason you feel that this figure is not sufficient, let us know. And from a practical standpoint, few, if any, employees are going to let you know. But what it does is it helps give you an out, or if it comes to it, gives me an out to say, well, hold on a second. They never raised the issue. They collected their $50 a month, or their $15 a month, or their $100 a month, and they took it. They never said it was a problem. And so how are we supposed to know? We don't know exactly what the expense was and what they attributed to it, or how much they were using it. The same thing goes for reimbursement. You give them something that's fair, that seems to be fair to you. You don't jip them on a couple bucks. You try to make it, and on pause on that issue. There's studies that have been done on this, right? Which is that reimbursement, the perceived value of a reimbursement to an employee far exceeds the monetary value or cost of that reimbursement to the company. In other words, if you, the company, give every one of your employees $150 a month for reimbursement, in the grand scheme of things, even if you're paying your employees minimum wage, that's not that much, right? If they're working 160 hours a month at minimum wage, that's a very small slice of the pie of what they are getting, but the value to them is tremendous. They really appreciate it. They feel like they're getting a free $160, right? Or $150, or whatever the number is. Do that. It doesn't cost very much to you on your bottom line, but it's going to pay dividends to your employees. So I think that's an important concept. Okay, let's talk about expansions to leave rights. And these are all formal expansions. And I want to talk about the concept that we're getting at, right? So a couple of years ago, I gave a series of presentations. This is before COVID, right? When we talked about other stuff about leave. And I gave it, in fact, to ACC again several years ago about the concept of leave and when we give it and why we give it and how we give it and what the definitions are. And the moral of my story, and this was 5 years ago, so 2019 or 18, thereabouts, was work backwards from yes on leave. And if you ever, as a company, have this aha moment where someone asks you for leave and you go, aha, we don't have to give that to you, you're doing it wrong. The law is confirming that time and time again in the last 5 years, and is going to continue, is granting more and more opportunities for leave. And my suggestion to you is that none of these should change your practices, because you should have already been doing all of this, and you should continue to do all of this. So the first way is that CFRA expanded. So it used to be there's the federal and the state construct, right? FMLA is federal, CFRA is state. And it used to be that they were both at 50 or more employees, with a few other definitions that came with it for employer size. Now CFRA has dropped down to 5 or more, meaning that not all, but most employers qualify, with the exception of very small businesses. So point is that far more employees are able to avail themselves of CFRA protections. Great. That means that they can avail themselves of the technical job protected leave as it applies to the state of California. However, if you ever found yourself, and I certainly am not asking for a show of hands here because I hope it's none of you, but I'm sure it's some of you, found yourself in a position where you have an employee that either you've got 49, someone comes to you and asks for what would effectively be CFRA leave, but you only have 49 employees, or they exhaust their 12 weeks of leave under CFRA, and you say, okay, there goes, that's the end of your leave, you're fired, and you work backwards from no instead of yes, you're going to have a bad time, and that preceded all of these revisions to CFRA and the other expansions to leave. Because the point is, at the end of the day, a leave can just in itself be a reasonable accommodation under the ADA, right? Under federal law, the extension of leave and the opportunity to provide leave can just exist outside of it. So in other words, if there's a technicality and you're saying you don't qualify because you didn't work 1,250 hours in the last year and therefore you can't get this, no, because then you're going to open yourself to the argument where this person who is having, for some reason, has to take leave for their own care, for the care of a family member, you're going to kick them while you're down and say, nope, sorry, you're fired. Just don't do that. Don't do that. And what that does is it bleeds into the other issues, right? Or the other ones that I've highlighted. And there have been some others in the context of leave, but these are the two most recent: the expansion to bereavement leave and the addition of reproductive health leave. Now, my suggestion to all of you is these should not have changed anything, to the point that I couldn't even tell you, as I sit here right now, exactly what the number of days is on bereavement leave. Here's why. I don't care. I don't. Because if you're the company that says, oh, I'm so sorry that your whoever, loved one, family member passed away, you only get blank days instead of blank plus 1 day. You don't want to be that employer. Because even if you drive a hard bargain and you can point to the law that says it needs to be this many days, I don't ever want you as my client to be the one saying, we're not going to give you that extra day of unpaid leave. You need to work backwards from rest, because you know who sues you? The people who get screwed in their mind, not legally necessarily, but in their mind, out of 1 day of work. That's the hook, right? And this happens with remarkable frequency. People are perceive themselves as being slighted, whether accurate or not. Sometimes it's true, sometimes it's not. And they're the ones who go after you. I did it years and years ago. I did a speaking series called Happy People Don't Sue. Well, and the idea being, if you keep your people content and you do what you're supposed to do and you treat them right and you treat them with respect and you treat them with dignity, those aren't the people that come after you. It's the people who get angry. Those are the ones who then they go to the lawyer. They don't go to the lawyer saying, hey, this law was broken. They say, hey, I'm pissed off at my boss, or I'm pissed off at my employer. And they might say that because grandma passed away and I had to fly to Chicago and I couldn't get back in time, and they punished me because I couldn't get back in 5 days instead of 4, whatever it was. Don't do that. Don't put yourself in that position. The same thing applies to reproductive health. I would argue that everything that came with reproductive health, which so that relates to if there's an incident of a miscarriage, or there's IVF time that you need off, or there is adoption issues, or there's anything related to anything under the sun regarding the reproductive health, you need to provide that. Well, here's the reality of the situation. Most, not necessarily all, because you can imagine some scenarios, but then it goes to family issues, are going to be medical. You provide medical leave anyway. So why would you as the company try to draw a line and say, aha, we can't provide you with that leave? Work backwards from yes. Give them the leave to which they are likely already entitled. And even if they're not, they're likely to be pretty angry if you don't provide it, especially when it doesn't cost you anything. It's going to save you a lot. We talked a little bit earlier about agreement or arbitration agreements. I want to talk about other agreements with employees. And I guess perhaps I should have put those slides next to one another, but here we are returning to it. So I apologize. But there are other agreements that we enter with our employees, whether it relates to during or after their employment with us. So I guess I'll kind of take this out of order, because the point is that or the reading between the lines of all of this is very similar to what we talked about with arbitration agreements, which is to say, if you're trying to drive a hard bargain with your employees, you're trying to unnecessarily muzzle them for the most part, whether that's in what they're able to say or what they're able to do, it's going to be a problem, right? So, and what I mean by that is, they need to be able to speak freely in a legal manner about certain things, right? So here's the concept. This happens all the time. A company says, well, okay, we're going to settle this lawsuit, this threatened lawsuit, but I don't want them talking about anything ever to anyone for any reason whatsoever. Can't do that anymore. You can't do that. Now, there for a couple of reasons. Silence No More Act talks about, you can't, that there are limitations on the ability of confidentiality agreements as it relates to harassment. There are also issues as it relates to disparagement language. So the McLaren-McComb decision, that was an NLRB decision that, McLaren-McComb talked about, I'm sorry, I'm having technical difficulties. Disparagement language. And what it said is that we can still have non-disparagement agreements, which we want, right? If we sign a separation agreement, we sign a settlement agreement with our employees, we want to say they cannot disparage us. What we cannot prevent is for them making truthful comments about their employment conditions, unless they're in a management level position, in which case you can muzzle a little bit more because they're the ones responsible for those employment conditions. But if they're not, they need by law to be able to discuss it. Now, I send this to clients and say, here's the agreement. They say, well, I hate that. Take it out. No. By the same token, kind of like what we talked about with arbitration agreements, I have clients where I'll say, okay, here's a settlement agreement. It's kind of, for now, it's good law. Here it is. You're letting people go. You can use this. Here are a couple things you need to fill in or change. Let me know if you have questions, but often they'll just take themselves. What I fear and what I know, because sometimes I see them after the fact, is the changes that may come. Because you or someone in your leadership team may look at it and go, well, why the heck are we letting this employee talk about work conditions? I want to shut them up all the way. This is why. Because the state of California, and in this case, the NLRB, so this is a federal thing, is telling us you cannot do things to muzzle your employees. You can't stop them from talking about working conditions, and you can't stop them from working elsewhere. That's what it gets to the non-compete. So there were a couple pieces of legislation. These came out, I'm almost positive, because I didn't put the date and I apologize. You could look them up. I think it was 2023 when they came out. Time just kind of blends together for me. But broadens the confirmation of what we're not allowed to do in terms of non-compete clauses. Now, we know in California we can't use non-compete clauses, but here's what happens a lot. I give that agreement and I say, here's an agreement. And I say to you, you can't have non-compete. And you go, okay. And then once I'm not looking anymore, you add in a thing that says for a period of 1 year after employment, so-and-so will not compete with the company. And the thought process behind that, I get. Because the thought process is you're thinking, well, I know it's not enforceable, but the employee might not. And maybe when he or she leaves our employment, they're going to say, oh, well, it says it there. I don't want to run afoul of that. And so I'm just not going to do it. What the law now says is that can't be in there. It can void the entire agreement. And you, the employer, need to go to your employees if there's anything that has that language in it and notify them and remove it and not have that anymore. Point being, you can't try to slip it by them. You can't try to chill their rights. You can't try to chill their ability to buy their trade. And so, again, you want the benefit of the agreements into which you enter with your employees. Don't hamstring yourself. Another common discussion point that we had before COVID changed the world was we wanted to talk about weed in the workplace. Because the biggest thing was Prop 64. It was back in 2018, I think it was, with the legalization of marijuana. And then we were trying to look in our crystal ball as it impacted our employees. So there hasn't been a ton of legislation until we got to the prohibition against off-work cannabis use a year or two ago. And what that basically says, we cannot, just like the title says, we cannot impede upon what our employees do outside of the workplace. Now, if you were listening to me talk about this in 2018, I would have said the exact same thing, because employees have a right to privacy. California employees or individuals in California have a constitutional right to privacy, to be free in their own affairs. And the problem is when that blends, right? What happens when someone does something at home versus when they come into work the next day? And how do we as employers deal with that? What the legislature is saying, and what I think is really important that we keep in mind, is not only that employees can do what they want on their free time, but we need to figure out a way to avail ourselves of the workforce in a way that is most meaningful and effective to us as employers. And what that means is the state and I, as an attorney, employment attorney, want you to look at your policies and figure out what they are and figure out if they're compliant with the law, and figure out ideologically if they are in keeping with your company's values and what it is that you and how you enact things and what you do. I can't tell you how many times I've seen something like this where I get a handbook, and at the bottom of the handbook, whether it's litigation commences, and I say, okay, I need to copy your handbook, and I get the handbook, and at the bottom of it says last updated in February of 2012, okay, or February 2004, or whatever it is. Okay, well, we got to figure out what to do with this because they're going to be problems. Even for the companies that regularly go through it, very often the drug policy is early on, and they look at it and they go to that page and they say drug policy. They say, okay, great, we have a drug policy. They don't even read it. They just move on to the next thing. What a lot of those policies say are things that are no longer consistent with what you as an employer are doing. Now, it may be that because none of this is intended to tell you how to feel about drug use. I don't care. You can feel however you want as long as it's legal to feel the way you do. But if your policy says we drug test everyone every 60 days because we can, and we're going to fire anyone who fails a drug test, one, you're probably not doing that, and two, if you says that and you're probably doing it in a way that's no longer compliant. So what you need to do is look for that compliance and change it to a way that works with what you are doing ideologically. Because I suggest to you that however many of you are in the crowd, there is a larger than you might imagine subset of you that quite simply don't have policies that are in line. So let's make sure that we protect our employees and ourselves from our employees in that way. And we just acknowledge the fact that this is a part of life. Particularly in California, there are charts that show this, right? That I don't need to know any of you to know that a lot of your employees are smoking weed. What are you going to do about it? Okay. I've got two more topics that I want to talk about, two big concepts that I want to talk about, and then we may have some time for Paga at the end. I want to make sure we have time for questions as well. So I think I'm on pace, but if there are any other questions, by all means, feel free to ask them. So let's talk about the creation of leverage, because one of the things that happens is, in California, the plaintiff's attorneys, by and large, write the laws. They have a very strong lobbying arm, and they push really hard to write laws that help employees. And ostensibly, that is to help the little guy, right? To help the to help the employee in asserting righteous claims against bad acting employers. Unfortunately, that can be used as much as a sword as it is a shield. And plaintiff's bar is well aware of it. We've seen that in a number of different contexts, particularly in the last few years. We've saw that there is now a rebuttable presumption of retaliation. That means that if someone engages in a protected activity, they blow the whistle, so to speak. There's a rebuttable presumption that that if they are fired shortly after that, they were fired because of it. Now, that doesn't mean that people are untouchable. Rebuttable means just that. It can be rebutted. It means that we need to be paying attention. We need to be paying attention. We need to have good documentation. We need to think through our decisions. We need to have managers that are trained. We need to make sure that we understand how we're going to enact our policies and make our employment-related decisions. So that way you don't create a situation in which you, as an employer, create a factual circumstance that looks bad, right? Because this happens. This happens with some frequency. I arbitrated a case not long ago where the issue was that someone had a ton of attendance issues, but then they also had, towards the end of their employment, made a couple of complaints and they got fired at the very end. And so the issue is that of timing. We have to deal with the perception where someone made these complaints and then why weren't they fired over the course of time before? And then all of a sudden, what happened was a manager said, enough is enough. the heck with it. I'm going to let this person go. Will it be fine? Yes, it's fine. It's okay. Not a big deal. But it could have been clean. And we could have thought more about the existence of that employee leverage. We also had a big case, this Lawson versus PPG architectural finishes case, that changed the standard as it relates to whistleblowing claims. And it's a burden shifting analysis, but effectively what it means, if the burden falls back to us as an employer, we need to present clear and convincing evidence that the plaintiff would have suffered the consequence, so would have been fired or would have whatever, but for the existence of something else, which is just a higher burden, right? The normal standard, as we all know, those of us who are attorneys from law school, or if you ever have a criminal background, well, so pardon me, don't have a criminal background, but if you have a civil background, it's preponderance of the evidence, which means more likely than not. We now need to prove as employers something by clear and convincing evidence, which is a higher evidentiary burden in the context of these 1102.5 retaliation claims. What does that mean from a practical standpoint? You're going to see a heck of a lot more. Every piece of litigation that could conceivably have a retaliation claim, you better believe there's going to be 1102.5 claim in there, because it just creates a higher burden for us as employers. You know, part of what I do, and just about all defense attorneys will do for just about any case, is we'll handicap it. We'll put together a report and we'll say, look, here are the likelihood of success on claims. And it used to be that typically we would kind of analyze retaliation claims in concert. We'd say, well, there are a few different theories of retaliation and recovery for retaliation claims, but in wrongful termination. But we're going to kind of analyze them together because it's likely that if one succeeds, the others will, or vice versa. Now, and it's this percentage of likelihood that you'll prevail. Now I have to add another line that says, well, actually, for the 1102.5, it's a little less likely that you're going to prevail because you have a slightly higher evidentiary burden. So that changes the expected outcome or the calculus of it, perhaps not by a huge margin, but at least by some. And so because of that, we have to deal with it. Now, not much we can do, because at the end of the day, employees engage in protected activity every day, not every day, but with great frequency. We're going to have to fire people, and sometimes people who've engaged in protected activity. It's just all the more reason to look at the prospect of leverage and do what we can to avoid the creation of additional leverage. Finally, from an employee leverage standpoint, there's the after the fact concept. And this is more for if you are in litigation and what you have to deal with as an employer in litigation. Statistically, I would imagine that many of you have had to do so. And what you know from your attorney, whether it's me or someone else, is that in the employment context in California, if an employer, if an employee prevails on his or her claim, then that employee is entitled to recovery of attorney's fees for prosecution of successful claims. Now, the question is, what if there is a partial victory? So in other words, you have 10 causes of action for retaliation, discrimination, harassment, failure to pay wages, et cetera, et cetera, et cetera. And some portion of those are successful, but not all. It's not as simple as simply saying, okay, well, it's going to be one cause of action out of 10 succeeded, therefore employee gets 10% of his or her attorney's fees. Not so. In fact, what it is it's all of the claims needed to prosecute those. So in other words, I'm doing a poor job of explaining this, but a lot of the argument is that a lot of that attorney time is by the plaintiff's attorney is spent litigating all claims in concert, and therefore it should be recoverable because you can't possibly peel out or carve out the unsuccessful claims or the litigation of unsuccessful claims from the litigation of the successful ones. All of this is to say that recovery of attorney's fees and attorney's fees awards are going to be larger, right? So in the Vines case, I don't remember the exact number. It's not particularly important, but it was something like plaintiff succeeded on 3 out of 11 claims, or let's call it 3 out of 10 because I can do that math. The court at first reduced it by 70% or so and said, well, we'll give you 30%, thereabouts. The Court of Appeal said, no, that's not so. In fact, it needs to be more like 80%. Don't hold me to these numbers, but the concept is to say it needs to be the lion's share because that time was spent litigating all claims in concert and therefore it's recovered. Once again, that creates leverage. That creates leverage that you as an employer need to be aware of and need to acknowledge because the failure or the inability to acknowledge that potential leverage will hurt you in handicapping these cases, will hurt you in results, will hurt you in the outcomes that you're trying to push. So I think it's kind of open and honest appraisal is really valuable as it relates to these cases. Okay, I have one more slide, and again, I wanted to leave some time at the end, so I'll be able to do that for questions and or Paga. I'll just keep talking. There are some changes that are industry specific, and you probably will tell me that a lot of you don't have any employees that qualify under the, whether healthcare employees or food handlers or fast food minimum wage employees. Understood. There's a question. I'll answer it. Well, so I had a question about when the rebuttable presumption of retaliation was enacted. I believe that was 2 years ago, and I apologize. I can double check that, but I believe it was 2022. Someone probably can find that, but I think that's the case. Okay, so for those of you that have employees, which is all, what you're probably already seeing is that even if you don't have fast food employees, even if you don't have healthcare workers, you're going to see kind of the rising tide and the impact of the changes and the financial and the minimum wage that is going to those is going to trickle to your employees, because it's going to do a few things. One, you're going to have people that say, well, if I worked in this industry, I can make this much money. Therefore, one, you should pay me more. And two, you're going to see employees that are less scared of losing their job. That's a little bit of an oversimplification, but I think it's the case. And here's the scenario that I envision. It goes to this idea of happy people don't sue, right? If you have people that feel like they're being taken care of and feel like they're being compensated fairly and appropriately, they're less likely to poke around and see what they can do. But if they feel like they're earning less than they would if they were to go to the fast food restaurant down the street, and they feel like you're trying to take advantage of them as the employer, even though there is no illegal nature to that concept, right? You're doing what you're supposed to do under minimum wage. You're running the risk that your employees are talking about. And if your employees are talking about it, those seeds of discontent are what can lead to bigger problems down the road. So what I want you all thinking about, if you have minimum wage or relatively low earning employees, is to think about the impact that can exist as it relates to other industries. Because your employees are talking about it. Even if you're not in this industry, they're talking about it. And the more that you can heed that and try to come up with solutions that might help your employees feel like they are appreciated and appropriately compensated, the more likely it is that you're going to find yourselves staying out of trouble. Again, that's not a legal concept. You're not going to have someone, if you're in manufacturing, someone can't sue you and say, well, I didn't get paid as much as the fast food worker, and therefore I'm entitled to that. No, of course not. That's not what the law says. You're still compliant with the law, but there is this possibility, or at least this prospect of a discontented or an upset employee causing problems in a way that you'd like to avoid. Okay, so with 7 minutes to spare, I know we have to kind of do a wind down at the end, or 6 minutes to spare. I leave it open to questions. If there are not any questions, and I'm allowed to keep talking and fill this time, I will talk to you about PAGA. So I'll kind of pause for 5 seconds here and see if anything comes up in the chat. If not, let's just make this a quickie PAGA thing. Is that okay with everyone? 5 seconds waiting. Okay. Diana said yes, discussion of PAGA. Okay, great. So blessing.
Yes, thank you, Ryan.
Perfect. I didn't know if you had a PAGA presentation tomorrow and I'm stepping on someone's toes. Great. Okay. So let's talk about PAGA. So I don't know how to do this in 5 minutes. PAGA is the Private Attorneys General Act. It had devolved of 2004. It had devolved into a mechanism by which the only people that made money were plaintiffs' attorneys. And it was going to be on the ballot in November to vastly reduce it and apply more money from the state to try to have the processes be more in line with what the genesis of this was, as it was signed by Gray Davis on his way out in 2004. Instead, there was two pieces of legislation that were passed in concert by both sides that everyone agreed. It was passed everyone, both on the worker side and on the employer side, came together and created these provisions. And what they largely do is streamline the processes. And it allows for employers like you to try to cure issues. Now, that's not necessarily going to come up in a lot of contexts, but if there used to be a few different narrow ways that you could cure if there are problems when you got a PAGA letter. Now there are a few different or additional ways. For example, if you have unpaid wages, you can cure those up now as well. And it also limits the way that penalties can be applied. And this is really good for employees or employers. The first and most important way is that if you as a company are proactive, you perform regular audits, you do trainings, you have manager trainings, you have manager discipline for managers that don't comply with good wage and hour practices, that can allow you as an employer to vastly reduce the rate of or the potential exposure to PAGA penalties, in some cases by up to 85%. So you can find yourself by doing everything the right way beforehand, you can limit or you can drop down to 15%, or in other circumstances, 25% or 50% can be the threshold at which penalties can accrue. That's hugely important because what we have is a PAGA is attributed on a per employee per pay period basis. So if you have $100 per pay period, now there are ways that can be cut down where the maximum under certain circumstances is, well, in some cases, 0 if it's been cured, or it can be 15, or it can be 25, or it can be 50. That's a lot of leverage for you as employers. We also know that for those of you who engage in weekly versus bi-weekly pay periods, you get some safe harbor. It used to be that this is all on a pay period basis. And so therefore, if you choose to pay your employees weekly, so you get 52 weeks per year, too bad. That means that you have double penalties. Now the penalties are cut in half if you're paying weekly. In other words, you're no longer hung on that, which is really important and can help reduce penalties significantly. Let's see, what else can I say? Depending on the size of your employer, there are also the number of employees that you have. There are opportunities for early evaluation conferences. In other words, you can get in early if you have more than 100 employees and say, we're going to go to a conference, we're going to try to settle this case early. What that likely means, it doesn't mean they're all going to settle, and we need to see this come into place. But hopefully what it means is that plaintiffs' attorneys are going to get a little bit more real about the value of these cases. It's going to reduce more. We're going to have a little more leverage on the employer side to try to avoid these runaway settlements. Let's see. Couple other important things. And again, I apologize, it's more scattershot. I'm just trying to think of what's important that I can talk about in 5 minutes. There are limitations on derivative penalties. It used to be that there were arguments that if you made a mistake as to wages paid, well, then that meant that there were issues on the pay stubs, which meant that there were issues with waiting time penalties. We can roll those up by and large the new changes to PAGA, which I think is important because what you want to avoid as a PAGA employer, is this argument that everything stacks. And now we, by and large, have done away with that, where we don't see cascading penalties. We have the new legislation tells us that there's a much higher threshold for having to pay the $200 per pay period double penalty. That's only if there are prior issues in the past that were dealt with. So all of this is to say, what can you as an employer do today? Start looking at audits. If you haven't already and you've been taking the position that it's better to try to just avoid this and cross your fingers and hope the PAGA lawsuit doesn't come, even with this reduction in how these cases work, the PAGA lawsuits are going to come. If you're an employer in California, it is a matter of when, not if. I all but guarantee. So start looking at your processes, because when you get that letter to the LWDA that starts the clock on a PAGA claim, and you send it to me or you send it to whoever your employment counsel is, I want to be able to ask and say, do you have audit processes in place? Do you do management training? Do you discipline where appropriate, where there are failures in practice? And if the answers to all those questions are yes, then you're starting with a vastly reduced value of a claim. Do yourself that favor today if you don't have it already. I mean, lots of companies are already doing similar things, but I don't care how big your company is, start doing it now. That will help keep you out of a world, but limit the world of hurt in which you'll find yourself down the road. So sorry, that was my 6-minute trying to jump all over the place with PAGA. If you have specific questions about this or anything else, by all means, reach out to me. I'm more than happy to help however I can. And as it is 1 o'clock, I will stop talking now. Thank you so much.
Thank you, Ryan. Any questions for Ryan? On any one of those topics? If not, his information is here on the slide. I'm sure he'd love to hear from you. Otherwise, thank you all for joining today. The slides will be up if they are not already on the ACC website. Thank you. Thank you, Ryan.
Thanks, everyone. Take care.